I want to thank everyone for being here to today's Judiciary meeting. Madam Clerk, if you go ahead and open the board members, let's take roll. All right. Madam Clerk, go ahead and take the roll, please.
Mr. Chair, you have 17 members present. You have a quorum.
Very good. Members, any personal orders before we begin today? Any personal orders? I would like to welcome the housing authorities from across the state. They're with us today. So if anyone's here from the housing authority, I want to thank you for all you do, moving forward with housing and the progress of that. So thank you for being here. And thank you. Very good. And we do have a calendar, but before we begin our calendar today, we have we're going to be holding judicial nomination hearings from our judges that have been given to us from the governor's office, and they are sitting there on the front row or the second row. But members, do we want to go ahead and go out of session to do so? But I will put on the record that we had calendared 3 judges. We had 1 withdrawal. We have 2. We have for our Supreme Court nomination, we have Judge Kyle Hickson. And for our Court of Appeals position in the Western District, we have Judge or Chancellor Maroney. So I did want to put that on the record. So without objection, let's go out of session and begin. All right. So if Chancellor Maroney, Judge Hickson, and Ms. Merrick, if you all would please find your way to the front there and have a seat. I'll ask the clerk to make sure your microphones are on as well. Good to let y'all get situated. You comfortable? All right, very good. All right, I'm going to start out by recognizing Chair Lady Littleton and Chairman Todd.
Thank you, Mr. Chairman. I just want to say I'm very proud to be a part of the nomination for Steve Maroney, Chancellor Steve Maroney. We go back a long ways. I don't want to tell our age or anything, but it's been a long time, hasn't it? And we served on the State Executive Committee, but I feel very honored to be a part of your nomination. I know you'll do a great job, and again, I'm very grateful to be a part of it. I'll always consider you my friend.
Chairman Todd. Oh, thank you, Madam Chair.
Thank you, Mr. Chairman. And I as well, I not only has Steve been a friend for a long time, but at least 40 years, I think. I have observed his steadfast dedication to the legal profession. I've worked beside him within our church as well as other community activities. Over the years, Steve has provided his service and leadership in several roles, including Madison County Attorney, Madison County Election Commissioner, Madison County Republican Party Chairman, University School of Jackson Board of Trustees Chairman, JACOA Board of Directors, and numerous faith-based initiatives. He has continued to he's continued his dedicated service to our community in his current role as Chancellor for the 26th Judicial District. He's one of the most level-headed, thoughtful individuals I know. His wisdom, strength of character, and sound leadership has given Madison County a great deal to be proud of, and therefore I wholeheartedly give my support for him to serve on the Court of Appeals, our judicial system, and the citizens of West Tennessee will be well served to have him on this bench. And I do appreciate Mr. Chairman allowing me to say that.
Thank you, Mr. Chair. And next, I'd like to recognize Vice Chair Elaine Davis.
Thank you, Mr. Chair. It's an honor for me to get to introduce Kyle Hickson. I think that you are an excellent jurist and you will make an excellent appointee. One of the things that I asked some friends with respect to you is they said he has a great sense of humor, and hopefully you won't have an office full of peanuts, packing peanuts, just like you put in some of the DA's office. But everyone that I spoke to, you became highly recommended. And that's one of the things I think that we're thankful for, is that we have someone that is very thoughtful, discerning, and that is of all.
Very good. Ms. Merrick, Would you like to say anything? Opening remarks?
I would. Yes. Thank you, Mr. Chairman and Madam Vice Chair and members of the committee. I'm thrilled to present these nominees to you today. And the governor and I thank you so much for your partnership throughout the entirety of his administration. It's hard to believe, but these are the 13th and 14th appellate appointees that we've partnered on to get confirmed for our excellent judiciary here in the state. I'd like to thank the representatives who introduced them. They have longstanding relationships with these gentlemen. Mine is shorter, but very rewarding. I've enjoyed getting to know them through this process and otherwise. As mentioned, Judge Kyle Hickson currently serves on the Court of Criminal Appeals in the East. He, of course, is the governor. He'll be filling the position vacated by Justice Holly Kirby when she retires. Chancellor Steve Maroney is chancellor for the 26th Judicial District out west, and he is the appointee for the Court of Appeals in the western section, filling the vacancy left by Judge Kenny Armstrong with his retirement. So we will make these gentlemen available for questions in a moment. Before we do that, and this will be a familiar reminder to the committee, we've done this several times, but recall there are certain questions that these nominees may not be able to answer, certain policy-related questions, things of that nature. They're prohibited from answering certain types of questions based on the Judicial Ethics Code. And we would not want them to be put in a position to have to recuse themselves on a later case or a certain issue that may come before them as their capacity as judges. So, Mr. Chairman, with that, I'd like to make these individuals available to you and the rest of the committee. Thank you.
Thank you, Ms. Merrick. Members, we're going to open it up for questions now. And I have Chairman Russell is first on the list. You recognize her.
Thank you, Mr. Chairman. And my first question is to Judge Hickson. Your experience as in criminal law, how will you learn the civil law you need to know to serve on the Supreme Court?
Thank you, Mr. Chairman. And that's a very good question. And I can say that will be my biggest challenge taking this job because I am a career prosecutor. My expertise throughout my career has been in the criminal law. But it's also the part about this job that I'm most excited about. Being a lawyer is a job of lifelong learning and growth and education. And that's something that I'm very excited about. I think if you needed to see a concrete example of how I would handle a civil issue or something that I was not initially familiar with, I would refer you to the writing sample that was attached to my application, where we were attempting to subpoena materials from Dateline NBC that were related to a homicide case that we were working on in Knox County. We were divesting a reporter's privilege in that, or attempting to, although it was occurring in the context of a criminal case. That was that's really a civil matter. It was nothing that I had dealt with before. But I hope you would see from that writing sample the amount of work and research that I would put in to any issue that I would encounter as a justice on the Supreme Court.
Thank you, Judge Hickson. And Chancellor Maroney, you spent nearly 30 years in private practice. Tell us about the types of clients and cases that you've handled over the years.
Yes, sir. Thank you, Representative Russell, and I appreciate the question, and I thank all of you for hearing from us today. My private practice was sort of divided into thirds. Roughly the first third of my 29 years, I worked for a mid-size insurance defense firm. I handled a lot of injury accident cases from a defense standpoint. The middle third, I went into private practice with a friend of mine who was an attorney that I'd gone to college with. It was a smaller scale civil practice where we kind of just did a little bit of everything that came in the door. And then the last third of my private practice, I became the county attorney in Madison County where I live, and I also became city attorney in a couple of smaller municipalities around West Tennessee. So it was a heavy focus there on local government.
Thank you, and I wish you both the best of luck.
Thanks, sir. Members, Leader Lambert, you recognize, sir.
Thank you, Mr. Chairman. Just wanted to say into the governor's office and to both candidates, I mean, obviously you were both extraordinarily well qualified. You both have extensive histories. I will say to Judge Hickson, while Judge Maroney and I have been friends for a very long time, and you have had an illustrious career that is now even being further elevated, and I look forward to voting in favor of your confirmation. Judge Hickson was an assistant district attorney just 6 years ago. So I was an assistant district attorney 14 years ago, and that is quite the meteoric rise through the judicial ranks. I cannot wait for you to be on the Tennessee Supreme Court. I think you did an excellent job there. I will say I think the pace will be a bit slower than being in a general sessions courtroom handling cases as an ADA. It's a little bit of a smaller docket, but obviously much more weighty cases. I only wanted to kind of reference that because it is interesting to me, the dichotomy between both candidates that are being put forward. Both have extensive histories, but have come to this from very different places. And I'm confident both of you will do a fantastic job. So I have no questions, Mr. Chairman. Just wanted to say a few words to brag on both gentlemen and look forward. I know we may have some additional nominees later in the session because I believe, if I'm correct here, Judge Hickson will be creating a vacancy if confirmed. And I think both you gentlemen will be on the ballot so the people of Tennessee can speak on this as well. So it's a big year for y'all. And thank you for putting your names forward.
Thank you very much.
Next on the list, I have Chairman Doggett. Sir, you recognize.
Thank you, Mr. Chairman, and thank you both for your willingness to serve in these roles. I've got a question, Mr. Chairman, for each of these candidates, if that's okay.
That's appropriate.
Perfectly perfect. Yes. Yes. Chancellor Maroney, I'm going to ask you, what is the biggest challenge that you foresee perhaps moving from the Chancery Court to the Court of Appeals, and then how might you navigate that?
Well, thank you for that question. I think the biggest immediate challenge I'm going to have is staffing. I've spoken to one law clerk who worked for Judge Armstrong, who's willing to stay on, and I'm happy about that. But his other clerk has moved on to other matters. So this is an unusual time in the cycle to be hiring. Most students graduating from law school are looking to start up in the fall. So I'll be interested in any names of promising applicants, if anyone has any. And I have postings listed. And longer term, I think just I'm not there to rearrange the furniture. I want to get to know the other judges and learn the procedures and systems that they have, and try to get myself up to speed to be of as much benefit to the court as soon as I can.
Mr. Chairman.
Thank you very much for that answer. Judge Hickson, being that you're going to the state Supreme Court, there was a very important court case from 1803 that established the process of judicial review. How are you going to utilize that case for when you interpret laws that come from the legislature, or maybe things that come from the executive branch going forward?
I assume you're speaking of Marbury v. Madison.
Yes, sir.
So it's interesting. I was reading about that case not too long ago, and we always throw that case name around, and it seems to stand for the very unremarkable proposition that the judiciary says what the law is. We interpret the law. And I was reading that in the context of the history at that time. That was not necessarily understood, because when we came from Great Britain, their court sat as part of the Parliament. So the idea in America that there would be this separate branch of government that would have the authority of judicial review was not necessarily obvious from the start. And it really came from the states. And that was something that I thought was very interesting, and I think illustrative of the fact that we do have 50 states that were intended at our founding to serve as 50 laboratories of public policy across the country. So I'm really looking forward to being a part of that. And thank you for the shout out to one of the most important cases of our history.
Chairman Doggett, any follow-up?
Well, thank you. And I know that probably wasn't one that you were necessarily prepared for. So I thought I'd throw you a curveball, but you hit it out of the park. So great job for both of you. I'm excited to see you both. Congratulations on your point.
Thank you.
Very good. And I have, again, Leader Lambert, you recognize.
Thank you, Mr. Chairman. And to Judge Maroney's comments. We have a member who happens to be a chairman who's taking master's degree courses in legal matters, who likes to ask questions about esoteric legal principles that he is now studying in class. So, Judge, if you need a temporary clerk, we should be adjourned in session by about the time you'll need one, and Chairman Doggett might be available.
Look forward to interviewing you.
Chairman Doggett, I'm going to allow you the opportunity to respond to that if you wish.
Thank you. My name was called. I will be available from the months of May through December for internship or apprentice, whatever I could do. I can also clean bathrooms and cut grass if you need me to do that as well.
There you go. All right. With that, how about let's go to Joe Towns. Representative Towns, you recognized.
Mr. Chairman, thank you. And judges to be, and thank you all as well for offering yourself up. Obviously, it's already been stated that, people that come before us are certainly qualified. As we met in my office, I'll reemphasize the two things that I'm concerned with. First thing is fairness to everybody. Just fair. Don't tilt the scale, just be fair to the citizens of the state of Tennessee. And the second one is following the Constitution. Can't fly by the seat of your pants. Can't make it up as you go. I think that document is the one that bounds this country together for the most part, a couple hundred years, going on 250. And that's something we can all work with. And if it's done fairly, people think they have not been mistreated. And I shared this as an example. If a couple of guys get into a fight and one guy gets the better slobber knocker and knock a joker out, he doesn't mind if the fight was fair. As long as he didn't pick up a brick and bust him in his head, he'll get up and shake your hand if he think the fight was fair. If the fight's rigged, he's not gonna like it, and he wants some revenge at that point. So fairness is a big deal for all of us in this country, especially if the shoe is on the other foot. And you can just briefly, give a little response to those two things.
Thank you for that, Representative. And it's something that has occurred to me. We were discussing it over the course of this week. These cases, we call them cases. And people would ask me, how many cases do you have on your docket today? And I would say, I would always try to remind myself and to remind the people that I worked with, those are not cases, those are people. You have 40 plaintiffs, you have 40 defendants, you have their families. These are people that we're dealing with. And as judges and members of the legal community, these are cases that we deal with every single day. But for the people who are individually appearing before you, they are dealing with perhaps the most important thing they've dealt with in their life, or perhaps the most tragic thing they've dealt with in their life. I recall when I was prosecuting, I would work obviously a lot with victims' families, and they would ask me, do you think we'll win? And my response was always the same. I said, no one's going to win here. No one's winning here. If we get a guilty verdict, that's not going to bring your loved one back. If we get a guilty verdict, the defendant's family is going to be losing a family member to incarceration. No one wins in this process. The best we can hope for is that people walk into the courtroom and both sides feel that they've been treated fairly, respectfully, with dignity, and that they walk out thinking that justice had been administered fairly.
Thank you.
Well, I'll echo those comments. At the trial level where I currently sit, it's not unusual for me to have litigants come in who are not represented by counsel. And I think it's especially important in those cases to try to, I can't play ball for their side. I remind them that I have to be the umpire. I have to call balls and strikes, and I can't pitch, I can't bat, I can't advise you whether to swing. But I do try to explain the process to them because I know it's unfamiliar. I feel like for those folks, the lawyers in the courtroom, the judges, the attorneys, we're speaking what may seem to be a foreign language. And it may seem like things are moving at 100 miles an hour to them when it feels like slow motion to us. And I try to slow things down and just make sure, even on the most basic thing, like reminding them which side gets to go first, I just try to make sure they understand the process so that when they leave, whether they've been successful or not, they'll feel like they were treated fairly and that they understood what happened.
Thank you.
Representative Towns, do you have any follow-ups, sir?
That's good. Thank you, sir.
Very good.
Thank you.
I have Chair Lady Littleton, ma'am. You're recognized.
Thank you, Mr. Chairman. This question will be for both of you, and we'll start with Judge Hickson. What legacy do you hope to contribute to the justice system in Tennessee?
So that's a very good question. Thank you. When I think of my legacy, I don't really think of my job as much as I love my job and what I do and how dedicated I am to it. I want my legacy to be my family. I want to be remembered as a good husband, a good father, a good friend to the people in my community. But since you asked about the judicial legacy, I would like to be remembered. Judges, I always like the saying, no one buys tickets to a basketball game to see the referees. Judges should not be the centerpiece of our government. We should be the least dangerous, as it's been said, branch of government, the apolitical branch of government. So I just want to be remembered as someone who worked hard, who loved the state of Tennessee, loved the people of the state of Tennessee, loved serving them for his entire career. And whether he got it right every single time, he tried his very level best to do that on every single case that he handled.
Well, it's hard to improve on that answer, but
That was good.
but I'll just add for a professional legacy. I hope on the Court of Appeals that the opinions that I'm fortunate enough to write will be opinions that are readable and understandable. And I think it goes a little bit to that fairness question and the understanding. From time to time, I'm called upon to deal with an obscure area of law that hasn't been litigated very much. And I might have to read an appellate opinion that's 100 years old. And they spoke differently back then. And they sometimes had 40 or 50 sentences in a paragraph. I want to have decisions that are readable and understandable, certainly for the attorneys who are involved and the judges who have to follow those precedents, but also for the litigants and for future citizens of Tennessee so that they can understand the law, because that's what we're doing this for, is the people of Tennessee.
Very good. Chair Lady Littleton, any follow-up?
Yes, thank you both very much, and I see that we've made some very good decisions, so thank you.
Very good. Next on the list, I have Representative Bolso. Sir, you're recognized.
Thank you, Mr. Chairman. I have one question for each of our judicial candidates, and I'll start with Judge Hickson. And it deals with conflicts of interest. And it's actually inspired by the question asked by your future law clerk, Chairman Doggett.
We may be fighting over his services, so
He raises Marbury versus Madison, which obviously was a decision that was written by Chief Justice John Marshall. And it involved whether Mr. Marbury should be issued his federal magistrates commission that was signed and sealed on the last day of John Adams' administration by his Secretary of State. And John Adams' Secretary of State was John Marshall. So back in 1803, for some reason, there was no perceived conflict between the justice writing an opinion about whether the commissions that he signed and sealed should actually be delivered to the recipient. But nowadays, I think we have a more modern notion of conflicts of interest, which is very important to the public. How is it, Judge Hickson, that the public can be assured that whenever you are on this very powerful role as a Supreme Court justice, that you will not have any personal involvement in any of the decisions that you participate in?
that would not have any personal involvement.
Personal, financial, or other business interests in any of the decisions.
I see
that
what you're
you'll
asking now.
be rendering.
Well, for one thing, I've been a state employee for my entire career, so I don't really have too many extraneous business interests going on in my life. Really banking on that pension someday. But I will say, through the Bureau of Ethics, we are required to disclose publicly any holdings that we have, any interests that we have, including those of our spouse and I believe our children, however meager they are. So that's something that's public record. I've been doing that for the 6 years now that I've been a judge. So that's all public record. And more than that, we have our moral compass, we have our rules of ethics. And if there's ever any indication or question that comes into play, the parties always have the ability to raise that through a Rule 10B motion.
Great. Thank you, Mr. Chairman. And Chancellor Maroney, my question for you deals with judicial philosophy, because obviously on the Court of Appeals, you will be interpreting the Tennessee Constitution perhaps even more often than you have in your role as a trial level chancellor. And we've heard some judge and justices describe constitutions as living documents. We've heard others take a textualist approach to interpretation of constitutions. Others take an originalist approach. Can you tell us where you fall along that spectrum and how it is that you will decide how to interpret our Tennessee Constitution of 1870?
Well, I'll give you the short version and the long version. The short version is stay in my lane. The long version is that if I'm confirmed for this position, my role would be to apply the law as it's written. In areas where there's any sort of ambiguity in the law, my job is to try to determine what those words mean, what they meant at the time they were adopted. With more recent statutes, that's a little easier. If you get into a statute that's older, you might have to do some research. What did those words mean at the time they were adopted by the legislature or the constitutional, constitutional drafters? But what I'm ultimately trying to do is determine what the words on the page mean, because what I don't want to do is inject my personal belief or my personal opinion, however well-intentioned. I want to apply the law that was adopted by you all. You all represent the people of the state of Tennessee. The law really is the collective wisdom of the state of Tennessee, not just as it exists in 2026, but as it's been developed for over 200 years. That wisdom, that collective wisdom is superior to mine. And I want to defer to that.
Very good. I have, I'm sorry, any follow-up?
No, Mr. Chairman, I thank you both candidates for those excellent answers.
Very good. Thank you. Chairman Todd, you recognize, sir.
Thank you, Mr. Chairman. I'd like for both of you to discuss a time when you followed the law, maybe even when you didn't like the result.
I'll start on that, I suppose. So that happens. It's been said, if a judge always likes the result that he's reaching, he's probably not doing his job correctly. So it certainly happens. Even during my time as a prosecutor, I can think back here recently, I authored opinion for the Court of Criminal Appeals where there was a search warrant that had an inadequate affidavit supporting its issuance. In my opinion, that was the result that the court reached. Law enforcement officers had executed the search warrant thinking that it was up to snuff. They had received an informant's tip that this individual, who was a convicted felon, was illegally possessing multiple controlled substances and guns. The informant was correct. This person was. But based upon my application of constitutional law, I realized that the search warrant was invalid, suppressed that and reversed that person's convictions. Now, I say this on one hand, and people have said this about the exclusionary rule, it comes at a societal cost. It's not a free check. The societal cost is there was someone who was obviously breaking the law. But what's more important than that, and why I'm able to put my head on my pillow every night when I make a decision like that, more important than punishing that one person is that we uphold the contract of the Constitution that the people have formed with the government. And if you allow that to erode, even in one case, you're doing a great injustice to our federal, our Republican system. So that was the case that came to my mind, Representative. Thank you for that question.
Well, thank you, Representative Todd, for that question. I would say the most difficult cases I deal with, I have a lot of family law that comes into my court. Those cases are always very emotional. The most difficult cases I've had to deal with, and sometimes have led to the sort of outcome you've described, have involved cases where the question is the termination of parental rights. Because that, from a civil standpoint, that's essentially the death penalty. When you say someone has committed grounds that are established by this body that essentially disqualify them from continuing as parents. And then I have to, having determined those grounds exist, have to then evaluate whether termination is in the best interest of that child. And the subset of those cases, which is the most difficult, is when grounds exist, but the parent involved has hit rock bottom. They've rebounded a little bit. They're trying to put their life back together, but they face, whether it's with substance abuse or other matters, they've not made it yet. And I have to rule, no, I'm sorry. The best interest of this child requires that termination be completed and that this child go on to be adopted by a loving family that's been able to take care of that child. Because I don't want to send that person back into the depths of whatever claimed them before. But at that point, I have to look for what's in the best interest of the child. And that's the mandate you've put upon me in the legislature. And it's the right thing for me to do. But those are tough decisions.
Any follow-up, sir? Very good. Members, anyone else? I have Representative Hardaway, you recognize.
Thank you, Chairman. And following along behind the clerk, the idea of textualism versus originalism, this is for both of you. Which do you most adhere to? What didn't come out with any clarity from your previous answer? And is it one or the other? Or maybe like former Supreme Court Justice Scalia, do you apply both?
I would say they're both. I think those terms are used oftentimes together and sometimes interchangeably, but that would really be incorrect. They are separate, distinct theories. When you talk about textualism, that means what are you looking to discern the meaning of a law? Some judges would say, well, you could look to the legislative intent, or you would look to the purpose of the statute. A textualist would say, you look at the text. You look at the text that was passed by the legislature, that went through this, as you guys know better than anyone, very strenuous legislative bicameral process, and was signed by the governor. When the people have spoken, constitutionally, that's how they speak, through the text that was passed by the legislature and enacted into law. Originalism is, on the other hand, is how you interpret that text. What meaning do you ascribe to that text? Judge Maroney, or Chancellor Maroney, pardon me, was discussing, we've talked about the Constitution of 1870. We had two constitutions before that. So we interpret newer statutes, we interpret older statutes. What is the best way to determine what those statutes mean? Originalism would stand for the proposition that we should give those statutes or those constitutional meaning provisions the meaning that they would have had to a reasonable reader educated in the language at the time they were enacted. Now, why would we do that? Because that was the understanding of the law as it would have applied to the people at the time it was passed. Is it a foolproof method? No. And I think Justice Scalia would have been the first one to admit that. He also would have been the first one to admit that maybe he did not follow that religiously throughout the course of his career. But he was always a very strong advocate for, while it was not perfect, it was the best and most fundamentally sound way to consistently interpret those provisions.
It's hard for me to improve on Judge Hickson's answer, but I agree with him. We're looking at what the text says. There are times when we have to, in order to determine what the text says, look for what the original meaning was. So I adopt and endorse his definition.
All right. And since we're not in class, I won't go into that any further. Volunteerism. Tell me your background in volunteerism.
Well, I'll start if it's okay. I've worked over the years with the Fellowship of Christian Athletes in West Tennessee. I was on the board of directors of that organization for several years. I was also on the board of directors for JACOA, which is the Jackson Area Council on, originally the A stood for alcohol. Now they talk about abuse generally and have widened that. You know, the folks who are served by JACOA are not always the most sympathetic to the public at large. It's not always easy to go out and try to raise their cause or try to help with funding for that mission. But those are people in our society who need help. Those are people who we find a large number of them want to get better. And I'm proud to have been able to work with those organizations. I'm also active in my local church, Fellowship Bible Church in Jackson, Tennessee. I hope that's the answer you're looking for.
And Representative, volunteerism is volunteer state. So on UT Day, I certainly appreciate that question. But that's always been an important part of my personal life. I recall in high school, I was members of various organizations. I recall volunteering at the Special Olympics, enjoyed being a hugger at those games. In my adult life, I've been a board member at CASA of East Tennessee, court-appointed special advocates, helping coordinate the folks who volunteer to go help children who have, against their will, been brought into the juvenile court system under very unfortunate circumstances. And I've also been a board member at Sertoma Center, which is an organization that Senator Bassey is very familiar with, that provides services and housing to intellectually disabled adults. It's intended to bridge the gap that is left behind when an intellectually disabled person leaves special education after high school. It helps them find the services and the housing that they need once they become adults. And also, our family are members at Sevier Heights Church, and we're active members there and participate in as many things as we can. And we're trying to get our 3 daughters involved in all of that so they understand the importance of how blessed we are to live in this country and to have our blessings. We definitely need to give back and help others as much as we can.
Only have one more, Mr. Chairman, and that's simply, what is justice to the victim? What is justice to the accused or the convicted?
I think justice is an elusive comment, and it kind of.
So let's do this.
Okay.
I'm going to let
Okay.
Mr. Moroni
Representative
go
Hardaway,
first.
Sure. Representative Hardaway, we're going to, Judge Hickson, you're recognized.
Okay.
Please.
Thank you, Mr. Chairman.
I'd like to hear Mr. Moroni first.
Okay, Judge Moroni, you're recognized, sir.
Sure.
Thank you.
Well, I'll tell you, in answering the question, my practice, as well as my judicial experience, has not been a criminal law practice. So I haven't been involved directly in pursuing justice. And if I'm confirmed by this body, I'll still be serving on the Court of Civil Appeals. But having said that, to me, justice, I think you said for the victim and for, what was the second part, sir? I'm sorry.
For the accused or the convicted.
Okay. Well, I think Judge Hickson said it a little earlier. No one wins in those situations. For the victim, I think the victim wants to be heard. I think she wants to know that the system has done what it can to see that whatever indignity or malice that's been inflicted upon her, whether it's a violent crime, a property crime, whatever, that some remedy has been attempted that will, it's not going to restore whatever she lost necessarily, as Judge Higgins said, but that there's some societal cost for the victim, for the accused, so that the victim feels like her loss has been recognized. And in terms of the accused in any criminal proceeding under our system of laws is entitled to due process of law, is entitled not simply to be summarily punished without having a chance for hearing with notice, with witnesses, and a chance, if necessary, to receive representation.
Thank you.
Yes, sir.
I would echo all of that. And that's what I was about to say. I was thinking back to what I would always tell the people I dealt with in court is that no one wins. Justice would be if we could bring a deceased victim back. Justice would be if we had some way where we could magically punish criminal defendants and then totally rehabilitate them and integrate them back into society. That's very elusive and impossible in most situations. So to me, justice is the fair administration of the law. This body, the Senate, sets what the law is. We have agreed, the people have agreed to live under these laws, under this system. And when there are disputes that they come into court and they get their fair day in court, they get their due process, they get their representation, and they receive the fair administration of the law. To me, that is justice.
And Mr. Chairman, I want to apologize to Judge Maroney for calling him Mr. Maroney.
I've been called worse, Representative.
Come in here.
All right. You have any follow-up, Representative Hardaway?
Thank you, Mr. Chairman. That'll do me.
Very good. Members, I have Leader Lamberth on the list.
Move we return to session.
Very good. Any objection to going back into session? Not seeing none. We're back in session now. So I would entertain a motion for each, one for Chancellor Maroney and then another for Judge Hickson for a positive recommendation from this committee to the full body of the Tennessee General Assembly. Representative Todd, you recognize.
Thank you, Mr. Chairman. I move that we confirm Chancellor Maroney to the Tennessee Court of Appeals Western Section.
Very good. And that's been seconded. Members, we are going to go on the board. Madam Clerk, if you would open the board up. Members, all those in favor for a positive recommendation to the full body of Chancellor Maroney to the Western District Court of Appeals, vote aye. And those opposed, vote no. Has every member voted? Does anybody want to change their vote? Madam Clerk, take the vote.
Mr. Chairman, you have 16 ayes, 4 noes, and 0 present not voting.
Very good. Congratulations, Chancellor Maroney, for this positive recommendation, and we wish you well. We know you're going to do a wonderful job. I want to also thank the governor's office for bringing you to us. I was so impressed with your experience and the way you handled the questions today. So I just want to congratulate you. Members, I would also entertain a motion for a positive recommendation for Judge Kyle Hickson to the Tennessee State Supreme Court to give to the full body. Chair Lady Davis, you recognize.
I make that motion, Chairman, that we have a positive recommendation for Kyle Hickson to the Tennessee State Supreme Court.
Very good. Chairman
Second.
Doggett, you're recognized.
Thank you, Mr. Chairman. I will second that motion.
Very good. Members, we're going to be on the board. All those in favor of a positive recommendation for Judge Kyle Hickson to be appointed to the Tennessee State Supreme Court, vote aye. Those opposed, vote no. Has every member voted? Does any member like to change their vote? Madam Clerk, take the vote.
Mr. Chair, you have 17 ayes, 3 noes, and 0 present not voting.
Very good. Congratulations, Judge Hickson, for this positive recommendation. I know you're going to do a wonderful job when you're confirmed to the Tennessee State Supreme Court. I practiced around you and with you throughout the years, and should have probably said this earlier. I've watched you grow. I've always been very envious of your ability to treat people fairly and conduct yourself with the professionalism and I've just been very impressed with watching you grow, sir. So congratulations. And I also want to thank Ms. Merrick at this point in time. I want to thank our governor, most importantly, for giving this committee the opportunity to entertain the caliber of the judges that we just heard from. And I was thinking to myself, out of the, 16 candidates I believe that's been in front of this committee, each year I think to myself, I walk out of this room thinking, I don't know that I can be more impressed. But today I'm more impressed. So I want to let you know sincerely that I wish you both the best. Thank you. All right. Okay. Members, we have a calendar, folks. I appreciate y'all sticking around for that. House Bill, item 1, House Bill 661 by Chairman White is going to be rolled to the Hill without objection. House Bill 661 is rolled to the Hill of today's calendar. That brings us to item number 2, House Bill 1552 by Chairman Powers. Sir, you have a motion and a second, and I do not see an amendment, so it looks like this bill is clean. So if you would, you go ahead and let us know what it does.
All right. Well, thank you so much. This is Secretary of State bill for the Safe at Home program. And the Safe at Home program provides victims of domestic violence and other crimes a substitute address so that an abuser cannot discover a victim's home through public records. So this one does 3 things. It updates the Safe at Home laws to allow a sibling to be a co-applicant. Number 2, it clarifies that a victim does not need another order of protection from a Tennessee court to enroll with the Safe at Home program when moving to Tennessee from another state. And number 3, it adds a persistent domestic violence offender registry that we passed last year to the list of exclusions for the program. And with that, Mr. Chairman, I renew my motion.
Very good. Any questions for Chairman Powers, members? And I would like to say this is a great program. Secretary of State, I believe, developed years ago. It's helped so many victims, folks that have been, stalked and just harassed. Allows them to sleep better at night, knowing that their address, their phone number is masked and protected. So I see, probably over the past 7 or so years, we continue to add protections for victims, for families, for children to be able to sleep well at night and know that they're protected.
Yes.
And I think it's just a wonderful, wonderful bill. And I appreciate you bringing that to it.
Thank you, Mr. Chairman.
Members, questions? All right. Any objections to the question? All right. Seeing none. Madam Clerk, you'd open the board. Members, all those in favor of all those in favor of House Bill 1552, vote aye. Those opposed, vote no. Has every member voted? Any member like to change their vote? All right, Madam Clerk, take the vote.
Mr. Chair, you have 19 ayes and 0 noes.
Very good. Congratulations. House Bill 1552 moves to calendar and rules. That brings us to item 3. That is House Bill 1508 by Representative Warner. All right. Representative Warner, you have a motion. You have a second. You're properly recognized.
Thank you, Mr. Chairman. It's an honor to be here in front of you today in the committee. House Bill 1508 seeks to extend the fee waiver of a lifetime enhanced handgun carry permit to include a retired law enforcement officer who served for less than 10 years prior to retirement, who was post-certified or had equivalent training on the date of the officer retired and retired from service due to an injury received in the line of duty as a law enforcement officer. With that, Mr. Chairman, I stand ready for any questions.
Very good. Members, do we have any questions for Representative Warner? I have Representative Johnson, you recognize, ma'am.
I was thinking that in subcommittee, did you say there was a minimum? Was there a 5-year minimum or just under 10? There's not, that you have to have served at least so long.
Representative Warner.
Thank you, Mr. Chairman. Right now, I think the current statute states that it's 10 years. What this bill would do would allow any officer injured in the line of duty to obtain these benefits.
Representative Johnson.
Okay, but there's not minimum amount of service before it kicks in. Okay.
Representative Warner.
Correct.
Thank you.
Very good. All right, members, any additional questions? I have Representative Hardaway, did you see your hand? You're recognized.
Thank you. And would it matter how they retired? If they retired running from prosecution or before they lost their post certification, would they still be eligible?
Representative Warner, you're recognized, sir.
I would assume if, that they were in any type of trouble, no, sir, they would not be eligible.
Any follow-up, Representative Hardaway?
Yes, sir. Just want to have confirmation on that. And if necessary, if you could amend your bill to be specific about that issue.
Any
Otherwise, I
comments?
support it. Thank you, Mr. Chair.
Any comments?
No, sir.
Very good. Members, any additional questions? I don't have anyone on the list. All right. Any objection to the question? Seeing none, we're on the board. All those in favor of sending House Bill 1508 to Finance, Ways and Means, vote aye. All those opposed, vote no. Has every member voted? Any member like to change their vote? All right, Madam Clerk, take the vote, please.
Mr. Chair, you have 13 ayes and 4 present not voting.
Very good. House Bill 1508 moves to Finance, Ways and Means.
Thank you, Mr. Chairman.
Thank
Committee.
That brings us to item 4, House Bill 1473. Have Chairman Bolso, sir, you are recognized. We got a motion and a second. And I don't see an amendment traveling with this. Is that correct?
That is correct, Mr. Chairman. There is no amendment.
Very good. You're recognized.
Thank you, Mr.
Counselor.
Chairman. Members, this is a bill that simply seeks not to change the law, but to clarify the law. You will all recall that in 2015, the U.S. Supreme Court issued its decision in Obergefell versus Hodges, which essentially held that under the Due Process Clause and the Equal Protection Clause of the 14th Amendment, that no state shall be able to deny individuals of the same sex the right to marry. What this bill does is simply clarify that Obergefell and the 14th Amendment apply and govern conduct of public actors, not private citizens. And with that, Mr. Chairman, I'm ready for questions.
Very good. Members, you've heard the explanation of Representative Bolso's legislation. Any questions? I have Representative Johnson, you're first on the list. Gotcha.
Thank you, Mr. Chairman. One question is, it talks about the lawyers can't be penalized. They can't find in a case. My question is there a case where lawyers in Tennessee have been penalized because they refused to do this? Is there actually some precedent? Because from what I'm hearing, this has never happened. Lawyers have not been penalized for this. And just wondering if you're aware of anyone who has.
Representative Bolso.
Thank you, Mr. Chairman. Representative Johnson, the board at issue here is the Board of Judicial Conduct, not the Board of Professional Responsibility. So that board does not govern attorneys. It governs judicial officers. And that's why it's here, because it would be judicial officers that would typically be involved in officiating at marriage ceremonies.
Any follow-up, Representative Johnson?
Yes. So have any of them been penalized at this point?
And I apologize earlier. Chairman Bolso, you're recognized.
Thank you, Mr. Chairman. Certainly, there was a case in Kentucky where there was an issue of penalties going against someone who was to officiate at a wedding. I don't know that there has been a case in Tennessee specifically on that point.
Representative Johnson, any follow-up?
Yes. Thank you. That's my understanding as well, that this is not a problem that we're having in Tennessee. And aren't private citizens already not bound to recognize marriages based on precedent that's already been set?
Chairman Bolso.
Thank you, Mr. Chairman. Yes, that is correct. As I indicated earlier, even without this bill, private citizens are not bound by the 14th Amendment or the Supreme Court's interpretation of it. That's why this bill actually clarifies that point. So all Tennesseans will understand clearly that they are not, as private citizens, bound by the Obergefell decision.
I just don't understand why we're clarifying, because it's already there. But thank you.
Thank you. And members, I apologize. We do have some folks that have signed up to speak today, and we're already running. We got about half hour left. Do we want to go out of session and allow them to speak, or do you all want to have, would you like to have a couple questions first? I'm open to whatever the committee wants to do.
Out of session.
Representative Salinas, you're recognized.
I'd rather hear them speak, but also my question is for legal. So
Okay.
I don't know if you want to take those if we're going out of session. at the time.
Would you mind to hold on to it and we'll,
Yeah,
we'll handle that when we get finished with our guests? Okay, very good. All right, members, without objection, we're going to session. We're going to hear from, if we could, looks like I have 3 signed up to speak on this list. I have Ms. Cohane. I believe I saw you earlier. Here you are. And I have Mr. Tom Lee. And I have Travis Meyer. And everyone can come on up and have a seat. And what we'll do is we'll just start over here on this side to my left, to your right. Sir, if you would introduce yourself, and you have 3 minutes to make any remarks you'd like to make, and then we'll move on down to Ms. Cohane and then so forth. Okay? So just be sure to introduce yourself, and the mic's on, so it's all yours. You have 3 minutes.
Hello, my name is Travis Meyer. I am a Lutheran pastor and biblical scholar, and I appreciate the opportunity to speak to this distinguished body. Thank you, Mr. Chairman. I'm here this afternoon to speak in opposition to this bill, and some of what I would like to say has already been covered by the bill sponsor, that it is simply a clarification and doesn't actually move the needle on anything except for things I suspect are behind the bill itself. And so my question as a taxpayer is, if this is only a clarification and does nothing legally, why are we wasting time and resources when there are actually things in Tennessee that need attention from this body that repeatedly get ignored? Second, since we've heard over and over again that there are no examples in Tennessee of people, not being able to celebrate or being chastised for celebrating, I say we open up the door to more celebrating if people want to join their lives together. I mean, there's enough negativity in this world. I have the privilege and honor of meeting with people in those moments and officiating weddings, and it is a very joyous thing. So why do we keep coming back to this issue? Why not make the table longer and invite more people into the process and celebrate life? And the one thing that keeps catching my attention in all of this is the language that gets used, and it was used by the bill sponsor again, this idea that traditional marriage is under attack. And that comes with a caveat that it's biblical traditional marriage, which has been present in other bills that I followed. So my question as a biblical scholar is, which of these 8 biblically defined definitions of marriage would you like to decide on? Because there are 8 of them. It's not just one. So let's talk about it. Thank you.
Very good. Ms. Cohane, if you would introduce yourself, your mic's on, you have 3 minutes. Thank you.
Sir. My name is Johanna Cohane. I'm from Robertson County. I'm speaking today because as a Republican, I've been raised to value the Constitution. I've also been raised to value the role of the Supreme Court and our system of checks and balances. I'm against this bill for many reasons, but the one I would like to focus on is the precedent that it sets. This bill states private citizens and organizations are not bound by the 14th Amendment or by the Supreme Court's purported interpretation of the 14th Amendment in Obergefell v. Hodges. In committee last week, Representative Bolso said numerous times that the bill did not make any changes, but was clarifying the application of the decision. It seems a more suitable form for this then would be a resolution and not a law, which sets precedent. The Constitution sets the laws for this country, and Tennessee is a part of it. States do not get to legally pick and choose which amendments in Supreme Court cases they will follow, just like private citizens do not get to pick and choose which state laws we legally follow. This bill sets a precedent that states and individuals or businesses can legally decide which amendments in Supreme Court cases to follow. Last week, when asked by Representative Harris for an example in Tennessee where this issue needed to be clarified, Representative Bolso began to answer with a 2018 case in Colorado, so not applicable. The 14th Amendment states, no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States. This law does exactly that. Giving permission to deny the application of the 14th Amendment and the application of a Supreme Court decision is exactly the state making and enforcing a law abridging the privilege of marriage from United States citizens. The Obergefell decision reads, under the Constitution, same-sex couples seek in marriage the same legal treatment as opposite-sex couples and would disparage their choices and diminish their personhood to deny them this right. Obergefell cites the case of Loving v. Virginia using the same equal protection clause. In Loving, the court invalidated a prohibition on interracial marriage under both the equal protection and due process clause. In making a law that states private citizens and organizations not bound by the decision, the state of Tennessee is doing exactly what Obergefell says a state cannot do. I would say that the precedent that this bill is setting is not right for the Tennessee, and I don't believe you do either. You may believe it will not be used in any further way. However, that is the danger about precedent. Once it is set, it does not abide by whether the one who sets it agrees or not. And the person who set that precedent does not get to direct how it is used in future cases. It follows its path. And this path is that a state or governing body can decide the Constitution and amendments do not apply. If you would not vote for this bill, if the line I quoted above, it read, instead of the 14th Amendment, the Second Amendment, and you would not vote for this bill if instead of Obergefell v. Hodges, it read Loving v. Virginia, then I would argue you do not support this bill and its precedent either.
Very good. Right on time. Thank you. Sir, if you would introduce yourself to the committee and your microphone's on and you have 3 minutes. Thank you.
Thank you, Mr. Chairman and members. My name is Tom Lee. I'm a member of the Board of Directors of the Tennessee Pride Chamber, and I'm here today to speak on behalf of that organization. Thank you for the opportunity to testify in opposition to House Bill 1473. The 14th Amendment is a cornerstone of our Constitution. It is the first and perhaps most significant byproduct of a great civil war. It guarantees not just what the sponsor has described. Section 1 alone guarantees birthright citizenship. It protects the privileges and immunities of that citizenship. It protects every person's life, liberty, and property without due process of law against state intrusion. And it says no state may deny any person equal protection of the law. The Constitution stands for our form of government. It is not something one recognizes. It is, and all stand equally before it. The Pride Chamber supports the rights of every Tennessean under our Constitution and the not insignificant commercial benefits that come from standing under the umbrella of those rights. Your auto insurance is cheaper if you and your spouse buy it together. Your interest rate on your mortgage is lower if you and your spouse borrow together. Married people transfer assets through a will, tax-free. They enjoy family leave and hospital visiting rights. Imagine if under this bill, a private employer said, well, you can't take family leave because I, as a private citizen, don't recognize, using the language of the bill, your purported marriage. Or a bank says, you'll pay the higher rate. We're not bound by the 14th Amendment. You're not married in our eyes. Or, I don't care if you have a Tennessee birth certificate. I'm not bound to recognize your citizenship because I'm not bound by the 14th Amendment, and that's why you won't get the job. You can see this bill as a trap for our business community and the Tennesseans that it serves. I'll end with history. The great state of Tennessee was the first Southern state to ratify the 14th Amendment in 1866, 160 years ago. It was therefore the first Confederate state to rejoin the U.S. 2 years before any other. This is our history. A people of this state who love this country, its institutions, and our Constitution. Thank you, members, and I'm pleased to answer any questions you may have. Thank you, Mr. Chairman.
And thank you, sir. Appreciate those remarks. Members, any questions for our guests? Representative Powell, you're recognized.
Thank you. I guess for Mr. Lee, if you could speak to Section 2 of this and maybe, I don't think you touched on that, discuss how that might be a problem.
And from this point forward, just members ask questions and guests. As long as you don't talk over one another, you all can go back and forth, okay? Without being recognized.
Thank you, Mr. Chairman.
You're welcome.
Representative Powell, the sponsor has it right. The provision in Section 2 covers the Board of Judicial Conduct. That's Title 17, Chapter 5, Part 301. And fair enough that a judge who is subject to the ethical sanction of that board may, in fact, refuse to perform a marriage ceremony, but that's the case right now. This legislature passed this bill just 2-3 years ago. It's in Title 36 in the Marriage Code, and it says, a person shall not be required to solemnize a marriage. Now, if we're talking about more than solemnization of a marriage, I think it would be important to know what that is, because I don't know what it means for a court to refuse to recognize the marriage of two people who were lawfully before it. But the Tennessee law is quite clear right now. If you don't want to do a marriage, you don't have to do it.
Okay, very good. Thank you.
Very good. Next, we'll have Representative Salinas. You're recognized, ma'am.
You kind of hit on this, but if this were to pass, would this be a negative impact on business?
I think so, Representative. Thank you for the question. I think business thrives on consistency. We talk about that a lot in this hall. And And I think it is dangerous both for business and consumers to say that when one is before a commercial enterprise and it makes a difference, whether one is married, maybe whether one is a citizen. It's not the option of a private citizen to say, I'm sorry, I don't recognize your citizenship, or I don't recognize that you're married and you're here applying for a mortgage together. Imagine a same-sex couple who has been properly married under the laws of our state and our country, and they go to the bank, and the banker says, I just don't recognize your right to be here as a married couple, and so I'm not going to give you a loan on the terms that you seek. That is bad for business and consumers.
And would it open those businesses up for litigation?
Almost certainly.
Thank you.
President Harris, you were on the list. Did you want to speak back in session? Okay, very good. Members, anyone else? I don't have anyone else on the list. Okay, while we're out of session, you want to entertain that question for legal? I think we can do that. Go ahead, you recognize. Representative Slanus.
Thank you. My question was, did the Obergefell decision include the word purported that is included in section 1?
Michelle Fogarty, Office of Legal Services. I'd have to pull it up and review it in detail to check. I don't recall that it used the word purported.
Okay. I've done some research and I believe that it doesn't include that word. And the inclusion of that word in this part of the bill is, I think, used in a pejorative, demeaning and manner, and implies that the state can decide whether one type of marriage and a different type of marriage, if it's same sex, doesn't count as marriage. You know, the law should be applied equally to everybody that seeks to get a marriage license, whether they're same sex or not. Okay, thank you. Appreciate it.
Members, does anyone else have any more questions for legal while we're out of session? Because I don't have anybody else on the list for our guests. Well, thank you all for being here, and without objection, we're going to go back into session. All right, members, do we have any questions to the sponsor? I have Representative Harris. You're on the list. You're recognized, sir.
Thank you, Chair. Thank you, Chair. Representative Balso, I know we've talked about this before, but does this legislation apply equally to marriages between opposite sex couples, or does it single out marriages between same-sex couples for different legal treatment?
Chairman Balso.
Thank you, Mr. Chairman. I mean, the bill, Representative, begins by saying that private citizens and organizations are not bound by the 14th Amendment. And that's true not only of the decision in Obergefell versus Hodges, but of any other Supreme Court decision interpreting either the Due Process Clause or the Equal Protection Clause of the 14th Amendment. The 14th Amendment is very clear that it applies to states. It says, in substance, no state shall deprive any person of life, liberty, or property without due process of law, nor shall any state deny any person within its jurisdiction of the equal protection of the laws. So in the text of the 14th Amendment itself, it's clear it applies to the state and to political subdivisions. It has never applied to private citizens.
Representative Harris, any follow-up, sir?
Yes, Chairman, and Representative, even though the bill talks about private citizens, with this legislation, would the state be authorizing and shielding that conduct?
Chairman Balso.
Thank you, Mr. Chairman. Could you clarify, Representative, about what conduct you're referring to?
Of picking and choosing between same-sex or opposite sex when it comes to marriages.
Mr. Chairman.
Thank you, Mr. Chairman. If I understand the question, the state is bound by the Obergefell decision. I mean, before Obergefell, obviously we had in Tennessee, both in code and in the Constitution, laws that specified that marriage was between a man and a woman. Those laws obviously have not been enforced since Obergefell in 2015. So Obergefell applies across the board to any type of marriage.
Representative Harris.
And thank you, Chairman. And in your own words, what exactly is the Equal Protection Clause?
Chairman Balso.
The Equal Protection Clause is a portion of the 14th Amendment. I think it begins with the words, nor shall any state deny any person within its jurisdiction of the equal protection of the laws.
Representative Harris? Any follow-up?
Of the state or of the federal laws?
Chairman Bosso.
Thank you, Mr. Chairman. It applies to states.
Okay, thank you.
Very good. Next up, I have Representative Powell. Sir, you're recognized.
Thank you, Mr. Chair. A couple questions for the three for the sponsor. So if Obergefell versus Hodges is binding constitutional law, then can you tell me how a state can enact a statute that declares private citizens and organizations are not bound by it, then according to the bill, notwithstanding any other law, without running afoul of the supremacy clause?
Chairman Bosso, you're recognized.
Thank you, Mr. Chairman. Representative Powell, if I understand your question correctly, the state can adopt legislation such as this because it is consistent both with the federal and our state constitutions. There's nothing in our federal or our state constitution that applies the law of the land provision or the due process clause or the equal protection clause of the 14th Amendment to private citizens.
Representative Powell, any follow-up?
So if a state affirmatively authorizes private entities to refuse recognition of certain marriages, does that authorization itself constitute state actions that trigger constitutional scrutiny under the 14th Amendment?
Chairman Bosso.
Thank you, Mr. Chairman. Potentially, yes, because when a private citizen acts in the capacity of a private citizen, the person is not subject to the limitations of the 14th Amendment. But if the private citizen is acting in some way as an agent of the state government or a political subdivision, then in that circumstance, the person likely could be found to be acting on behalf of the state, and therefore that person's conduct would be governed by the 14th Amendment.
One last question.
Okay.
If this bill allows private organizations to refuse to recognize certain marriages notwithstanding other laws, then how does that square with the equal protection guarantees when state law creates or authorizes differential treatment?
Chairman Bosso.
Thank you, Mr. Chairman. I mean, that is the case, Representative Powell, because for as long as we've had the 14th Amendment, our courts have consistently held that the 14th Amendment is a restriction of and it applies to state governments. It is never applied to private citizens.
Thank you.
All right, next on the list, I have Representative Salinas. Ma'am, you're recognized.
Thank you, Chairman. Because the Obergefell decision does not include purported as part of its decision, I would like to make an oral amendment and would like to move to strike the word purported from section 1 of the bill.
Very good. That's the proper motion, proper second. We have objection?
Objection.
Okay. Okay, members, all those in favor of considering Representative Salinas' oral amendment 1, say aye.
Aye.
Opposed, say no.
No.
Amendment fails. Now we're back on the bill. Any further questions? Representative Hardaway, you recognize, sir.
Thank you, Chairman. I think Representative Salinas spoke to the first purported. I'm not understanding how we can say that the ruling of the U.S. Supreme Court is purported in terms of the interpretation and purported in terms of that second purported marriage between individuals of the same sex. So I'm curious, and I would ask the sponsor to clarify why he needed purported relative to marriage between individuals of the same sex.
Chairman Bosso, you recognize.
Thank you, Mr. Chairman. Representative Hardaway, that is in there because of Chief Justice John Roberts' dissent in Obergefell. When you look at the very beginning of Chief Justice Roberts' dissent, he makes clear that the Constitution had nothing to do with that 5-4 majority decision. And he obviously is correct because, as we heard earlier, Tennessee adopted the 14th Amendment in 1866. It was ratified by 3/4 of the states and became law in 1868. And just think for a second from what we heard during our judicial confirmation hearings, that the way that the Constitution should be interpreted is to look at the text of the amendment and how it was understood at the time it was enacted. When Tennessee adopted the 14th Amendment in 1866, marriage in Tennessee was limited to one man and one woman. There is no one in the state who would have conceived that anyone could look at the Due Process Clause or the Equal Protection Clause and say that what we were doing when we adopted the 14th Amendment was to guarantee a right of individuals of the same sex to marriage. That proposition, which the majority in Obergefell adopted, is absurd. It is absurd in the extreme. It was one case where the Supreme Court completely went outside of its jurisdiction and decided something that it wanted to hold, even though there was no basis for it in the Constitution. And that's the point that Chief Justice Robert was making in his dissent, and that's why the word purported is there.
Thank you, Chairman Bolso. Charlie Littleton, you're recognized.
Thank you, Mr. Chairman. I call for previous question.
All right, very good. Question's been called. The objection? Seeing none. All those in favor of sending House Bill 1473 to calendar and rules, vote aye. Madam Clerk, if you'd open the board. Vote aye. Those opposed, vote no. The question's been called. So, Madam Clerk, give them one so we have some technical. No, we had no objection. All those in favor? Oh, that's okay. That's fine. That's fine. Hey, we'll recognize objection. Members, all those in favor of previous questions, vote aye. Or aye. Those opposed, vote no. Previous question prevails. All right, Madam Clerk, if you'd open up the board, please. All those in favor of sending House Bill 1473 to calendar and rules, vote aye. Those opposed, vote no. Has every member voted and any member want to change the vote? All right. Madam Clerk, you take your vote. Thank you.
Mr. Chair, you have 13 ayes, 5 noes, and 0 present not voting.
Very good. Very good. Thank you, members. I would take a motion to adjourn. Okay, motion. So adjourned. All right.